you know, where you have a case where 4 commissioners take a different position, and then 3 take a different position, and then we have a declaration of a presidential winner. Do you think we should look at Article 138, 3, and maybe final, second last? You have mentioned something about the picking of the new commissioners for IEBC, and you say this, what we need is to have a process that has a confidence building among Kenyans. And you mentioned that the panel that is in place was put in place in a fairly toxic political environment. Do you have a proposal as LSK, or now we can deal with that issue, bearing in mind that we have already a team, as you said, that is in office through a legally recognized legal process? And I want you to think around what happened in 2011 when the EACC Act was amended and removed some directors from office as a way of reconstituting the EACC. Could we have some input from LSK? How we will create a panel that enjoys the full confidence of Kenyans to recruit commissioners. Then the final one, on these offices of Prime Cabinet Secretary, Leader of Opposition, you have said we need to respect the Constitution as it is. And you mentioned we could choose to be parliamentary, we could choose to be presidential, or we can have a mongrel. Can you develop a position on all these 3? You know, bearing in mind what you say, that there is a candidate who carries like half of the country. You know, in the US, the running mate moves to the Senate, becomes the president temporary of the House. So he has a place to run to. The others can continue being senators. If you go to Australia, it's if you don't win majority, you become the leader of official position. So you have a role to play with your support base. In Kenya, you are either inside or you are outside and nowhere. What do you think will be the best system for us? And bearing in mind that we are a bicameral house with the National Assembly and Senate. Otherwise, thank you, Bwana Chairman, for your thoughts. And as I said, I hope you'll give us a comprehensive memo so that it can assist this team. Thank you, Bwana Chairman.
Thank you.
And if I leave Chair President, it's not because I don't respect the answers you will give, but it's because I sought permission to step out for an engagement at 11:30. Thank you.
Thank you, Senator Mugeni. Maybe, President, if I may also begin from that Article 138, in regard to what Senator Mugeni has raised, 138.3, as read together with 138.10, that says within 7 days after the presidential election, the chairperson of the Independent and Boundaries Commission shall declare the result of the election and deliver a written notification of the result to the Chief Justice and incumbent President. That read together with Article 138.3 that says, after counting the votes, 38.3c, after counting the votes in the polling stations, the IEBC Commission shall tally and verify, count, and declare the result. And I read that, and you are the lawyers, yourself and Senator Mugeni, but at least I have the benefit of having gone to Alliance, so I can read English and be able to interpret English. I went to Alliance, so therefore, Mr. President, and from the reading, my reading of 138.10, my interpretation of that is that the returning officer for the presidential election is therefore the chairperson of the commission. Just like at the constituency level, there is a returning officer at the sub-county level who tallies and declares the result. How he does it, whether he has clerks or he uses his presiding officers who, in a sense, would be the commissioners at the sub-county level, I think is the same way I would interpret the Constitution, that the chairperson is the returning officer of the presidential election. And therefore, when 3C says that the commission will tally and count that result, then therefore it behoves on the chairperson, the returning officer, to ensure that there is a proper tally. And if you read that together with the Supreme Court judgment of 2017, in terms of declaring that the results at the polling station are the last results, all that the returning officer is left to do is to put together what was declared at the polling station, then declare the result as a tallying officer or as a returning officer. Therefore, maybe you would confirm, even without being a lawyer like yourself and Senator Mogeni, whether that indeed the chairperson of the commission is the returning officer who either himself or through a system he puts in place will tally those results to enable him to declare that result. Because it is assumed that for you as the returning officer to declare results, just like the returning officer who declared myself and Senator Mogeni at the county level, he tallied and he had a system that he put in place. That will confirm. Two, Mr. President, you spoke to the urgency of the reconstitution of IEBC, and I completely agree with you, and I think many people who have appeared before us have spoken to this urgency. And you said that if there is consensus in the reconstitution of the IEBC selection panel that even LSK sits in a process that you build confidence in the political class. And you seem to be telling us that this is more or less a political problem, not a legal problem, because the legal framework does exist. And in fact, it is that legal framework that we conducted the last two elections under, through a selection panel. There have been propositions to go back to what was referred to as the IPPG format of appointing commissioners. There have also been proposals by some quarters to use what happens in other Commonwealth jurisdictions where the president unilaterally appoints commissioners. In your view as LSK, what would be the best option to have the current legal framework that we have, where we have an independent selection panel, to go the unilateral decision of the president, or to go the IPPG invention of 1997 in Kenya? Lastly, on audit, if I heard you right, you said that we need to look into a way to entrench a proper audit framework into our legal architecture that obligates IEBC after every election to look into their processes.
That has been answered for me.
I want to believe that one was not answering me. And therefore, my listening to you, I got the sense that you're also saying what we've heard before, that IEBC should be obligated after every election to have a look at the processes. And maybe the Article 88, I think that Honorable Eugene was reading for us, 88H, on evaluation of elections. Probably listening to what you're saying and looking at that article, maybe the Constitution was asking IEBC then to be obligated to evaluate their own systems after an election, because the same Constitution has also obligated other state organs and institutions like the Supreme Court to be the one to review election results. And therefore, the Constitution never envisaged at any one time that there shall be an audit of election results by IEBC itself or any other organ other than the judicial system. Therefore, I just want a clarification, because when two other groups appeared here, they spoke about an audit of the processes, and maybe you can confirm whether that would be accurate. And thank you, because you spoke about credibility and confidence building by political players in that process, and it seemed like you are pointing fingers at the political class and not the absence or any lacuna in the legal framework on the reconstitution of IEBC. But I indeed agree with you, there is indeed great urgency in the reconstitution of IEBC. Mheshimiwa Catherine.
Yes. Okay, thank you, Chair and President of the Law Society of Kenya, Mr. Deul. I've listened to you very keenly as a lay person, and I noticed it's like you are opposing generally many issues that are supposed to be entrenched in the Constitution, just from a layman's point of listening. When I looked at the 2/3 gender rule, you actually just came out clearly and said we need to implement it. But you have not given us any suggestions or any formal framework of how to go about that. And maybe any other issues that you think can help this committee to beef up the 2/3 gender rule implementation. And also on the entrenchment of the funds, you clearly came out actually also opposing it. Whereas when you come to Parliament, there's this amendment with initiative by Parliament in Article 256(1)(a), where parliamentarians and a bill can come through Parliament and be amended. But you seem to just be saying, it will not be possible to have these funds entrenched. That is the CDF, GAF, and maybe these other funds that you have mentioned. However, I'm also in support of the judiciary fund being entrenched. But why the judiciary fund alone, not alongside the other funds, if it is a question of having them entrenched? Maybe we would look at it from a layman's point of view, that maybe to cushion the judiciary from some of these weird characters we normally come across, that would also be a way of cushioning them. On that point, maybe I would agree with you at that level. But on the offices of the two leaders of opposition and Prime Cabinet Secretary, you also seem to not be supporting it. Maybe give it more reason as to why you think this should not be entrenched in the Constitution, especially if we can come up with a parliamentary system or an initiative through Parliament to have this improved. Thank you.
Yes, Omar. First and foremost, my sincere apologies for coming late. I had indicated to the team that we'll be running a little late today. Question number one. I had your presentation, by the way. I got a brief on it. Is there anything in law or in the Constitution that stops a presidential candidate from also running for member of parliament or member of the Senate? In that, we've seen in the United States, a sitting senator can run for president or a sitting governor. When he or she loses an election, he goes back to his role as senator or governor or whatever other elective position. Is there any deterrence, just to pick on your views, that, for instance, stops Raila Odinga from running for member of parliament for Langata, and upon his loss, rather than create the leader of official position, he becomes the leader of minority, and therefore holds the position held by Wandai, so that then we don't fundamentally change the architecture of the Constitution? Is that a practical thing? What do you think about it? Number two, talking about Article 43, there is a lot of politicization. The Bill of Rights is my forte for a while. And there is this Article 21(2), which talks about the state shall take legislative, policy, and other measures, including setting up of standards to achieve the progressive realization of the rights guaranteed under the Constitution or under Article 43. Progressive means it's not so suddenly that Kenya Kwanza is accused of not delivering on Article 43, and it doesn't mean you reduce purely or subsidize consumption. It actually means an entire program that is sustainable. An election is two competing sets of vision. One wants to subsidize production, the other wants to subsidize consumption. We have said we are expecting a harvest that then would probably speak to the prices of food. I do agree that we cannot blame entirely the global dynamics, but we cannot also live in a vacuum. We actually did a G2G. If you compare Kenya with other East African countries, there are less queues, or there are no queues at our petrol stations. The demand on the dollar has been greatly alleviated. There are no shortages of fuel. So in its holistic sense, one cannot say that our programs are simply not working on the basis that you don't agree with them because you used to subsidize production, or consumption. So, but in terms of a legislative framework, I remember I proposed a legislative framework which was supported in terms of a framework law that actually went through the Senate, but then did not get concurrence in the National Assembly. Is a legislative agenda in terms of streamlining Article 43, in terms of our budget policy statements, in terms of our county government CIDPs. Is it a possibility so that we entrench fully? And it's not that some casual pedestrian measures that are being suggested by our opponents on the basis of what they think, because there's a cost of living issue at the moment. It has to be a programmatic, systematic.
Point of order, co-chairs. I think we had said
but you said a lot of things.
Utmost respect.
You said a lot of things
to our colleagues. Is in order to really call some of our views pedestrian. Really, those are our views.
Yeah, they could be pedestrian.
So, Honorable Omar, let's be a bit civil in the language you use.
I even think that if your application to the Supreme Court is weak, it can be hot air. So it's a question of terminologies, of how you think the depth of an application. And they don't probably say every other application before them is frivolous, hot air, based on innuendos and rumors. It was not fundamentally in the Court of Laws. But anyway, the last one is on the panel. It is made to appear like the amendment of 2023 was about, or is it 2022? Number 1 of 2023, I think, was a response to a court decision that one of the organs, I think it was PSC, or is it Parliamentary Service Commission, was overly represented. And therefore, the court directed that no one singular organ can nominate that many people to a panel. It was never done by Kenya Kwanza as an affront to control the IEBC. It was a response to a court ruling. In your own estimation, should the political parties play any role in this panel after all? And what is that, the extent of that role? I might not have heard your particular views on that one, because I believe elections are not just about political parties or two competing coalitions. It's about every Kenyan. So do you think that panel, if reconstituted, must be political party heavy, or must be politician heavy, or must be cared, but what must have, maybe even have more representation from LSK? You appear to be, I might disagree with a lot of things you do, but I actually realize that at some times that kind of audit is very essential for our democracy.
Well, I think that, President, you have a lot to respond to. I don't think you need to deal with everything. You remember there was an invitation to present a written memorandum which can actually incorporate some of these thoughts that you have heard from members. I'll add one more for you. There's a finding by the Supreme Court in their famous, or is it infamous ruling, that
the chairperson of IEBC actually created an illegal office. What do you think should be done with that finding going forward? Thank you. Oh, sorry. Amina Mnyazi, and then we can conclude. Yeah.
Thank you, Chair. One of the challenges we face for the rule of law is the disobedience of court order. So my question will be, how do we enforce court orders, and what should be done to the public and state officers who ignore these public, who disobey court orders?
Well done. One of the reasons we're here is because we had demonstrations. And we had the Inspector General of Police come out very strongly, obviously in contradiction of what is, again, under the Bill of Rights, Article 43 and all the other rights, to declare demonstrations illegal. We will probably need to get a thinking of the Law Society as well in that matter, because as a result of all that, I think partly that's the reason we're here, to have this dialogue and to be able to correct some of these, call them injustices. So, but as I said, you have plenty in your hands now. You may deal with it, some of them now, or give us a memorandum, because as Senator Mgen said, you have a statutory duty to guide all of us. And thank you.
Thank you. It's indeed flattering, the amount of questions that have been thrown my way. But I'll deal with them. I think in the process I might answer questions that were posed by two different members of this very, very honorable committee. Co-chair, my former vice president and a member of my senior council, on the question of audit, and I think I'll respond to this and also touch on the question that Honorable Wamalo and co-chair Mr. Honorable Ichungwa also touched on. On the question of audit, I think we need to make an election. We can do both. We can look at the past, that is the 2022 election, and audit it, see what lessons we can learn from it and move forward with those lessons. Or we can say that we look at the framework, and I think the legislative framework requires a little bit of panel beating, so that then we impute in the system itself, we put in adequate mechanisms to ensure that there is an audit of the process, and all the parties and the members of the public, if they need to, have a way to access those audit results, irrespective of whether there will be a challenge or not. And I say this because the IEBC in itself is also bound by the Constitution to ensure that it manages the election in a manner that is transparent and in a manner that is free and fair. And so on the question of transparency, and if you look at now Article 88H, and then look at perhaps the question of evaluation, you can find enough constitutional grounding to impute such audit mechanisms, because they go towards transparency. What the Supreme Court does within 14 days is to determine the dispute. But what we are saying here is that IEBC spends public resources to conduct an election. in the spending of public resources to conduct the election, it is bound by the Constitution in terms of how it spends its money to ensure that that money is spent in a manner that is transparent. So whether there will be a dispute or not, and perhaps this is one question that is always faced by those that seek to challenge any election. And you know this because perhaps some of you have lost an election and some of you have won an election. The challenge on the person challenging an election is always to get the material to rely on to challenge that election. Of course, there will always be the argument you needed to have agents and you needed to have all that. But in a system that is transparent, that information should be readily available. If technology was used, then an audit of that technological system ought to be available in terms of the penetration tests, in terms of the logs that are necessary to convince each and everyone that the election was conducted free and fair. And I think we need to perhaps interrogate the obligation on the IEBC to conduct a free and fair election. How far does it go, and do we have the necessary framework? And I believe that we have enough time to be able to do that so that we can settle the law before we get to the next election and have a system that is predictable and a system that then meets the constitutional thresholds. And, of course, what I regard to be extremely unfortunate words that came out of the Supreme Court when they were describing the petition. And then we all know that sometimes the problem of justice is one of perception. And so language is one of the things that then creates also perception. But I think that the thing that we must not lose in the criticism of the language that perhaps the court may have used is actually the actual merit of the pleadings that were before the court, and actually whether the court in the end delivered a fair decision on the basis of the pleadings that were placed before it. And I think that should always be the standard, so that we have a very fair criticism of the judiciary, because, again, part of the things that can eat into judicial independence is an unwarranted criticism of the judiciary, either attacking their competency or raising allegations of corruption against the judiciary. And then you see, those are things which we are seeing happening, and we hope that we can have a system that then protects the very, very important principle of judicial independence. I think on delimitations and the creation of a different, perhaps, body to take to consider the question of delimitation of boundaries, Honorable Chair, Co-Chair, the challenge that we begin to have is one of how the two entities work together in terms of being able to prepare for an election, because an election is not an event, and the delimitation has a direct impact on the preparations for an election, considering what the Constitution says, if they're held of the period that they can actually impact the next cycle of elections. That would be one. And two would be, unless then it is an ad hoc setup that comes into play, because the period we have is less than not less than 8 years and not more than 12 years. So that if you are to set up a different entity to undertake this function, you have this challenge of what does it do after it has finished this function? Does it stay moribund, enjoying public resources, which we are also saying are rather scarce at this particular time, or should we just have it done by IEBC. So I think there is considerable merit in having it done by IEBC. I think the problem we find ourselves now is somehow a unique problem that does not require us to respond to this issue in the manner of either separating the two roles. And of course, you also know that this in itself attracts considerable litigation if the experience of the first time this was done is anything to go by. So I think it would be much better done if it is done by IEBC, because again, it goes into radically affecting the structure of the Constitution because of the way IEBC is titled under Article 88 as an election and boundaries commission. Honorable Eugene and my Senator Omar, I think on Article 43, we always would start with the balance of progressive realization. But for me, and I think this is the challenge that we are actually facing right now, is that whereas there is the concept of progressive realization, the question that I think that is before the committee is not one of the actions that the government has taken to achieve progressive realization, because this is a mandate that ideally is bestowed on Parliament, and it should be checking on some of these things. How are they being done, and what are the steps that are being put in place to progressively achieve some of those rights? The question for me, I think, is a question of Article 201 of the Constitution. When we are looking at the question of the cost of living, we are basically addressing ourselves majorly on Article 201. I will not speak so much on it because the Law Society is in court challenging certain aspects of the Finance Act. But I think the question that we really need to ask ourselves is the object of taxation purely about getting revenue to sustain government activities? And I think that's the question that Kenyans are asking. That there are taxes after taxes after taxes after taxes. Yes, those are intended to collect revenue for purposes of supporting government activities, which is granted, and under 201, that is what should be done. But is that burden being shared fairly? And I think those are the questions that we are asking. Is taxation, can we use taxation to achieve other means? Are we looking at any proposals that are coming out on taxation to, for example, spur development or economic activity in certain areas? Are there incentives that are being given through taxation to cushion those whom are facing a very heavy burden as a result of the current measures that have been put in place on taxation? And I think those are the questions that each and every one of us is meeting. Remember that the tax measures that are being implemented are not being implemented in a vacuum. That people had planned their income in a particular way. There's the question of 2/3, ensuring that at least someone can take home 1/3. In terms of law, that is, from what we are hearing, that is completely breached now because of the element of taxation. And so the disposable income that is left to the ordinary mwananchi has shrinked significantly by virtue of recent measures of taxation and the increase in the cost the cost of living attributable to the global macroeconomics, which we cannot blame anyone for. So the question then becomes, how has the government responded to these difficulties that are faced through taxation to alleviate that suffering? And I think that is the concern, and that should be the question that we should look at ourselves. And for me, I want to say that, and I think, Eugene, you asked me if I have any suggestion on what can be done to deal with the cost of living. I think the solution lies in Parliament. That you should actually go back to Parliament and ask Parliament to look at the recent legislation, irrespective of what the courts are going to say come November when they deliver their decision. It should go back to Parliament and Parliament to look at it and say, what can we do to give incentives on the cost of living? Chairs, let me just confirm that we will be issuing a written memorandum on some of the issues that we have raised. And of course, for me, I think the question of corruption, the question of impunity is one, and I want to tie this to some of the the question that I was posed with regards to some of the declarations that were made by the IG on demonstrations. It's really about what you would call the tone of the country, and in terms of the tone of leadership. You have a tone of leadership that supports constitutionalism, a tone of leadership that supports the rule of law, then everyone else falls into play. But if we get a tone of leadership that seems to suggest that aspects of impunity can be entertained, and of course I know that during the time of demonstrations there were fractured political tensions, and so one would say this and the other one would say this, but you would expect that institutions that such as the National Police Service, which ideally are created under the Constitution, that then would only be guided by the Constitution. We've seen instances of cabinet secretaries attempting to transfer police officers contrary to what the Constitution says. We've seen fights between the National Police Service and the National Police Service Commission in terms of who can transfer when the mandate is clearly set out in the Constitution. And so that speaks to a culture of impunity and to a culture of a lack of constitutionalism. And we need to ask ourselves, who is setting the tone for this growing culture of impunity and disregard to the Constitution and the rules that we have? Chair, you did ask about, and also I think Honorable Eugene did ask about 138(3)(c). In my view, and I think this is the position that the Law Society took at the Supreme Court under on the amicus brief, when it comes to tallying of the results, under C, it is the joint responsibility of the Commission. But under 10, when it comes to the declaration of results, it is the responsibility of the returning officer who is the chair. And so I don't think that there is any ambiguity in that. What needs to be done is just to comply with the decision of the Supreme Court, and I think the Supreme Court did agree with the position that the Law Society took then in the amicus brief in terms of the corporate ownership of the decision and the announcement part that being made by the chair. Yes, Senator Omar, I also agree with you that the reconstitution and the act was done pursuant to the decision that was made in Okiya Omtata. And I think that's where we are having a difficulty, and it becomes a little bit, and that's why we're saying this is more of a political question than a legal question. Because in terms of the panel, yes, the panel is there. In terms of the law, yes, the law is there. What would we have preferred? Perhaps we would even have preferred, in my view, and these are the views that we presented to Parliament, that professionals, and we look at it, who would have desired to have at least have perhaps gotten 2 slots into the selection panel, so that you bring in more of the professionals than the political actors. So in terms of political parties participating in choosing the referee for their game, it becomes a very tricky affair, because it is, the IEBC is not just for politicians, so to speak. There's a need to professionalize IEBC, because the professionalization of IEBC then leads us towards creating confidence in the processes that the IEBC would take. So our view would be we need to comply with the law as it is. If there is a crisis of political confidence in that process, then the right place for that to play out would be to Parliament. But the idea would be to try and get a law on a selection panel, and I wouldn't support the IPPG format, because that was an extraordinary situation that required extraordinary measures. I think we are out of those extraordinary situations. We've managed elections twice or thrice, and we've had the law clarify so much what the elections ought to be. So the political climate, in my view, is fairly settled. So we just need to have an independent panel infused with proper professionals who can be able to give us a selection panel that enjoys confidence of the entire country. Let me just, Senator Omar, tackle one question, and then I'll go finally to the question of the judiciary fund and why the judiciary fund. There's, when you look at the Constitution in terms of Article 137 on the qualifications to run as a president, being a state or public officer makes it difficult for any other person other than who is then disqualified under subsection 2, other than then the qualification that is given to the president, deputy president, and a member of parliament. And I think that perhaps this of course is a feature that is there in the U.S. system, where the elections are not held at the same time. So perhaps one of the things we can look at is it time to amend the Constitution so that the elections are not held at the same time, because that way, if Senator Mogeni, who has just left, is serving as a senator and wants to vie for president, he can, because his term in office is still there, he can vie for president. And if he's not elected, he goes back and continues to serve in parliament. Would there be considerable merit in separating the terms of when elections are going to be held within the Constitution? Because in itself also it creates a very difficult problem. It makes the election extremely difficult when you're conducting about 6 elections at the same time. But then again, it has also its own obvious political consequences that may make that proposal extremely, perhaps, not very popular with the political class. But this, I think, are probably discussions that can be looked into with a view of enhancing the current system that we have, because, again, very legitimate. About 49 or 48% of the country has voted for you, yet you cannot be able or be in a position to dictate or to challenge government policy and build yourself up in terms of your status leadership. That is something that ought to be considered. I'll finalize my responses with the two concerns that were posed by the ladies in the House, the honorable ladies in the House. The first is by Honorable Ambilianga with regards to the entrenchment of these funds. And my concern is so much about how you achieve, by entrenching these other funds into the Constitution, how then you achieve the principles that are set out in Article 201, running all the way to 206 on the Constitution, that talks about equity in the sharing of revenue between national and county government, the vertical sharing of those resources, because those would be the concerns that any attempt to entrench these funds would create in any of the proposals that will be given. And that is a legal hurdle that must be surmounted. And going by the decisions that have come out from courts, it almost looks like any attempt to do that would still be challenged, and the courts are likely to come back to a particular outcome. The judiciary fund is already provided for in the Constitution, and that is why we are basically just saying that we make it much more effective by ensuring that we look at the regulations and remove this interference by doing that. So that I think answers that. And finally, on disobedience of court orders, my simple response to this would be, and this is what we have said, that we just need to have fidelity to the Constitution, to understand that the judiciary, that all of us need a judiciary that kicks very hard. When it kicks you and it is painful, you know that the day your enemy is on the other side, it will kick him equally as painfully. And so therefore, a hard-kicking judiciary is painful in certain instances, but you know that the same pain would be inflicted if you were on the other side. And so it is a necessary evil, so to speak. And so I would urge that we all take the necessary steps to ensure that we have a proper functioning judiciary.
Well, we thank you.
Thank you so much.
We thank you so much. You notice you've taken quite a while. Co-chair Ichungwa told you have 20 minutes. We've gone into an hour, but it's important. You didn't even have time to address the matter, very important matter, the 5-point agenda of fidelity to political parties. But we cannot do that now. And in your written submissions, we can also, perhaps as LSK, look at that.